Good afternoon, everyone. Thank you for being here. As state's attorney, I swore an oath to faithfully perform three primary duties. First, to protect the Illinois and U.S. Constitution. Second, to seek justice. And third, to protect the public. It is after thoughtful consideration of these duties that I have joined a bipartisan group of Illinois state's attorneys and sheriffs and filed suit on behalf of my office, Sheriff Caruana, and the people of the state of Illinois to challenge the constitutionality of the pretrial fairness portions of the Safety Act. Among other things, these provisions eliminate cash bail in this state entirely and severely limit judges' ability to detain defendants in custody following their arrest and pending trial. The filing of this litigation does not categorically rebuke criminal justice reform in this state. Many of the public policy objectives within the law are well-founded and well-meaning. However, I cannot ignore the fact that as currently drafted, this law is unconstitutional. Further, it will create unjust results, and it does not protect the public. Accordingly, it is my duty as your state's attorney to fight it. Our suit challenges the constitutionality of the law on the following legal basis. First, the law violates the single subject rule. Second, it violates the Illinois Constitution in that it deprives defendants of the right to be, quote, bailable by sufficient sureties, end quote. The law violates the rights of victims guaranteed by the Illinois Constitution. The law improperly interferes with the court's supervisory and administrative responsibilities, also known as the separation of powers doctrine. The law violated the three readings clause of the Illinois Constitution. And lastly, the law is unconstitutionally vague. The litigation of our suit and others is likely to be consolidated, or in other words, combined and moved to another county in Illinois. Filing suit here in Winnebago County seeks to ensure that any decision a judge makes in another county will apply here. So if a judge in another county were to hold that the law is unconstitutional and stop it from becoming effective on January 1, that would be applicable here in Winnebago County. Despite the filing of this litigation, and I can't emphasize this enough, I, along with many state's attorneys throughout Illinois, remain committed to working with legislators to make necessary changes to the law. These changes should include, at a minimum, the elimination of the detention net. Eliminating the detention net would allow judges the discretion to detain an individual charged with any crime based upon, one, their risk to the public, and two, their potential interference with the administration of justice. Despite what some have said or intimated, I am not a proponent of returning to a cash bail system. However, I will remain a vocal critic of this current version of the law because of its shortcomings. We must demand better. Ultimately, I am advocating for a law which appropriately balances a defendant's presumption of innocence against the court's interest in the fair and orderly administration of justice and the community's safety. I remain hopeful that we will get there. But in the meantime, I will bring every tool to bear in defense of the Illinois Constitution, the rights of all involved in our criminal justice system, and for fundamental public safety.